SJC-11638, Thomas C. Abate, B. Fremont Investment and Loan, and others.
If it may please the court, Your Honor, my name is Tom Vaughter, and I represent Thomas C. Abate in this matter. This is a case which originated as a petition to try title, which is a peculiar statute drafted in the 1850s, updated in 1890, 93, I believe, and it still exists today in the form from back then. The statute's pretty clear as to the procedural aspects of someone who wishes to bring a tri-title action. It sets out exactly what the procedural aspects are. And where much of the confusion seems to be in these cases is the distinction between a petition and an action. The action in a tri-title petition case doesn't occur until an adverse claimant comes forward and says, yes, we are an adverse claimant, and yes, we believe we have better title or some title, and they then bring an action.
So is the reason that you do this, I mean, since your client was challenging the validity of the foreclosure sale because of the validity of the assignment, is the reason that you or he wanted to proceed with a tri-title action as opposed to a declaratory judgment action is that it then puts the burden to actually go forward on the whoever comes up as the claimant?
That is certainly one of the reasons. One of the problems that mortgagors have, or former mortgagors have, is that they don't know what in fact happened. The burden is very hard for a mortgagor to elicit the information that they need in order to show what happened or didn't happen. So a tri-title petition, which would result in a decree ordering, if there wasn't a voluntary answer from the respondent saying, yes, we want to come forward, yes, we bring a tri-title action, that the court would then issue a decree saying whoever is making this claim needs to come forward.
Well, one thing they do know is they didn't make their mortgage payments.
Well, the record's not clear on. I mean, I don't want to dispute. I understand there's issues about mortgage payments are not in default, but that's not what's before the court as I understand it. What's before the court is
what is the person foreclosed because they didn't make their mortgage payments.
Well, again,
just a point.
And
some other reason for the foreclosure? Some other violation of the mortgage?
The record is not clear as to what actually happened early on. I do not want to suggest that there was not missed payments. I do not want to suggest that the default may not have been for failure to pay. But the question is, who is the parties who are foreclosing? Who has the right to foreclose? That's the question.
So help me understand the procedure. I bring a petition claiming that there's a clouded title and that I'm a title holder, and I ask whether anybody else will come forward to say that they are the title holder. You come forward and you say you are also a title holder. Then the burden is on you to bring a separate action, or can you bring it in the same action?
I believe the statute permits that a separate action can be brought. The practice, as I understand it, is that the land court will accept a counterclaim, which then in turn becomes the lead case. So if they bring a counterclaim, which says this is the action we bring, that rather than bringing a brand new action, they bring a counterclaim, which is then responded to by, as we're sort of the defendants in that, which we then respond to, and then there is litigation that goes forward.
Is this a counterclaim in the Soldiers and Sailors Relief Act?
No.
No.
In what kind of a case?
The counterclaim would be brought in, so The petition would then be converted by the land court into a tri-title claim action, it's no longer a tri-title petition, by allowing the respondent or the adverse claimant, whoever that is, to come forward and do a counterclaim.
So I just want to follow up on the procedure here. Okay, so your client files the petition and names those various parties as potential claimants, right?
Well, so, in thinking about it, whether this was done correctly or not, or whether I do the same thing the next time, what I did do is I listed in the caption
Right.
those parties I thought that may have, but the petition itself doesn't mention, it doesn't say, here is MERS and their address is, and they are a party to this. And the statute itself indicates that the court is involved in the process of determining who ought to be brought before the court, who ought to be summoned.
Okay.
And that can be done by, that can be done by a public notice. It can be done by, and in this particular case, when appeared before Judge Foster, he indicated, yes, serve these 4. Let's start there. So I did serve those 4.
Okay, so
But I just want to be clear. It's not. It's not the normal naming. It's not anybody who can make a claim and who has an adverse or possible adverse. It doesn't have to be.
But I take it that I don't remember this from looking at it, but I take it the petition, whether or not you name these other people, the basis for thinking there is an adverse claim in your client's case is that somebody has foreclosed and his claim is they didn't have a right, so now they claim they have a title. So the people that were the entities that were involved in the foreclosure are going to be maybe not named by name, but their existence is going to be in the petition.
I think that's reasonable. I think we generally know some, but we don't necessarily know who, in fact, holds the note and mortgage. That's the point. And in a petition case, there's somebody who's claiming and standing as if they do, and we're suggesting that they're not really the mortgagee.
Okay.
Counsel, what do we make of the fact that in the bankruptcy court, your client indicated that he would surrender title to the bank, suggesting that there was no question here that the foreclosure could go forward?
What I would say to you is that I don't feel like I can spend my time going that way, other than to say that the statement of intention by a party in a bankruptcy court to surrender a piece of property requires the bank to respond and actually come and take the property within 30 days of that statement. And if they don't, under the bankruptcy rule, and I'm not an expert, so I don't really want to get into this piece, but if we had flushed this out, and if we had gone down that road, and if we had done discovery, it would be my contention that the issues that were raised in the bankruptcy court have no impact on this particular case.
Well, just a minute. I'm just wondering whether or not you have to establish that the other party is adverse, right, in this tri-title action?
No, I don't. I have to say that we believe, we have a record title, and Mr. Abate had a record title.
But the whole reason that you're doing this is because presumably someone else has a claim, maybe not necessarily a superior claim to the title, right?
Clearly, you bring it because there's somebody out there that is making a claim, or you believe is making a claim. Absolutely. It's not in a vacuum.
So,
Correct.
so the statement that's made in the bankruptcy court is totally irrelevant to the adverse nature of the claim that's being made?
And again, I'm not a bankruptcy expert, but as I understand it, the bankruptcy case finally would not have any impact on this case based on what happens when a party signs a statement of intention to surrender a piece of property, that requires action by the mortgagee within an X period of time, and if that doesn't, it then goes forward. And what happens in this case,
Well,
what
but
happens...
literally a week after you filed your intention, the bank can't just come in and take the property. It filed a notice to lift the stay, so it could.
But,
And it got, that notice to lift the stay was granted about 2 weeks later,
But
and then the
that's-
foreclosure proceeded.
But that's a completely separate decision made by the bank not to come and get the property,
It
but to...
can't co- if it's, how can it come if there's a stay, a bankruptcy stay? How can it come and foreclose on the property? Isn't that the whole point?
What I would say is that I'm not an expert in bankruptcy. I do not believe, if we had an opportunity to do discovery on this, in this matter, I do not believe that the bankruptcy proceedings would finally be dispositive of any issue in this case. And I don't know how, I mean, we can go there, but
No, but in
it's
any
really
event,
beyond
that's not what Judge Foster did, so
Yeah, and he
it's
did
not
not do
what he
anything.
did.
So, you know, I'm glad to have that argument, but I don't think that's what
You
is...
say we don't need to get there.
Yeah.
We don't need to get there.
The judge said, we don't even get there, you lose on other grounds.
Right, because...
Can we get back to Judge Foster?
Because Judge Foster made the mistake of treating the petition as an action, that it was a claim
Okay,
brought
let's-
by my client rather than a petition.
All right. What I want to ask is this. I'm wondering whether you read Bevilacqua as suggesting in this kind of situation, which was the opposite. In other words, it was the title holder after the foreclosure who's coming in. That's Mr. Bevilacqua. But as suggesting that in that situation, that if you are claiming as one of the jurisdictional facts that you hold record title, right?
A record title.
A record title, and there is a I don't know what you call it, respondent, but anyway, the mortgage holder who's gone forward with the foreclosure comes in and says, look, here's an assignment, and brings a 12B1 motion. I know that wasn't the case in this here, but brings a 12B1 lack of jurisdiction, and I thought Bevilacqua might suggest that the burden would then be on you to establish affirmatively the jurisdictional facts.
And I would suggest that we did more than establish that
But what you
fact.
did was allege it, but I mean, do more than that.
Well, that's part of the problems with the title statute, is that other than alleging it, I don't believe that for purposes of the petition, I need to do more. Once it's alleged, it's sufficient. It's the question of who comes and brings an action that needs to go forward. So it's not to say that I don't think that there would be a party that the mortgagee could come forward and do a 12B1 motion, saying that there is no record title or my client's not in possession. There are jurisdictional issues that Bevilacqua noticed, and the jurisdictional issues are whether my client had a record title and whether my client was in possession.
So you're saying, I take it, that a petition to try title is a device to flush out anybody who has a claim, and if somebody does come forward and says they have a superior claim, they then become the plaintiff in the case.
Correct, or any kind of claim, right. They become the plaintiff, and they have the burden of going forward. That's right.
But in this situation, I mean, I'm not sure it would make any difference in the sense that, okay, you're saying you should be in the second phase of this trial. That is, they should have the burden of going forward. So they do go forward, and they say these things, and aren't we in the exact same place that we're in here?
I don't think we are, because again, the burden is different. So the burden is different.
Right, the burden
and
to
I
go,
don't think
the burden to go forward, or the burden of proof?
the burden of proof
But
and the burden of going forward.
it's going to be a record issue in this kind of case.
So as in a declaratory judgment action, as in a quiet title action, it's not appropriate, from my perspective, to do a motion to dismiss on the merits in those types of actions.
It's not.
And so it's not an appropriate vehicle to do a motion to dismiss in this type of an action.
So in your world, what should happen is they should file a counterclaim and then move for summary judgment or move for required finding.
Correct. Or judgment on the judgment on the
And I guess
pleadings, whatever they want to do.
going back to Justice Botsford's question, what's the practical difference between resolving it that way versus resolving it essentially through a motion to dismiss for lack of subject matter jurisdiction?
Because the practical piece is that someone needs to come forward. And so
Well, they have come forward.
these people don't necessarily...
They've come forward to move to dismiss, so...
Well, so take, for instance, MERS, who has disclaimed in this case, essentially disclaimed, who has filed a motion to dismiss. What standing do they have to come forward? The basis of the complaint, and I see that I'm over my time, Your Honor, but the basis of the complaint, if MERS disclaims on it, they have no standing to even appear. If Carrington doesn't have an interest, they don't have a basis to come forward. The only party that might have a basis is someone who actually claims to have an interest in the property.
Well,
and
but,
yes.
but MERS's position on not having an interest depends on the validity of the assignment. Because if the assignment isn't valid, it does because it was the original mortgagee.
Well, Your Honor, so their original mortgagee of record, I would agree with that. Whether they have any other abilities or not, that's a separate issue also. But I'm.
I'm still confused. Put aside those who disclaim. Okay, let's assume that somebody who does claim ownership moves to dismiss for lack of subject matter jurisdiction. Is there any functional difference between the adjudication for that, between them filing a counterclaim and moving for a required finding, or them moving to dismiss for lack of subject matter jurisdiction?
What the practical difference seems to me to fail in light of what the procedural obligations are that are set out by the statute, which are very clear. Because the purpose of it, the purpose of the petition is not to have discussion on the merits. The purpose of the petition is to bring parties, because the petition, if it goes through, can result in the land court forever barring parties who may or may not have a claim against the property. So that there is something that happens down the road that is depending, could be draconian to certain people who might have an interest. Because they can forever bar it. So the idea is that procedurally, and the statute is clear what the procedure has to be, and it's not, I would say, it's not governed by Mass Rules of Civil Procedure that did not come into existence for 80 years after the statute came into existence. I would say that the rules of civil procedure do come into play once there is the standard A versus B. Once there's the standard action for tri-title, then we're in a place where the rules would apply. But where the statute set out what the rules are, what the procedure is, and what the extent of the court's determination can be, the extent of the court's determination under a tri-title petition is not on the merits.
Wouldn't it be easier to file an action for injunctive relief and name, give a name of a defendant and plus any others unknown, and then during the course of discovery find out who these other people are? It seems to be a lot less cumbersome.
Well, my experience, and limited as it is, my experience in this world is that we don't get to that point because we do not have sufficient understanding of what the factual background are or is with respect to the documents, their execution, whatever else is going on, who actually holds it. So once we have an injunctive situation or any situation where we are the affirmative party, we have a problem that has been shot down repeatedly on motions to dismiss because we don't have sufficient facts to go forward. So this is a way, as Judge Botsford noted, this is a way to change that, to give an opportunity to a mortgagor to have discovery as to determine what in fact is the circumstances as to who may in fact own the note in the mortgage, sufficient for them to be able to go forward.
All right, thank you.
Thank you very much, Your Honor.
Good morning. My name is James Rogal. May it please the court. I have with me Robert Broken, who represents Mortgage Electronic Registration Systems, Inc. He'll speak at 3 minutes left in the argument. Your Honors caught the issue in the crux. What is the consequence of filing an action acquired title? And I suggest that if you look at the decision written by the judge in the land court on the motion to dismiss, that he addressed all the concerns that were raised in the action to try title, disposed of the case. And it's important to note that those reasons, those grounds for the motion to dismiss weren't appealed here today.
But the argument is that it should have been your burden, I guess it would be Deutsche Bank, I'm not sure whose burden, but somebody in this defense side, to show the validity of the assignment and all the steps involved, right?
It did.
And so,
It did to satisfy the
well,
requirements.
it filed the record of assignment, or a copy of the record of assignment, right?
Yes.
What else?
Well, that was the basis of the action to try title, that the assignment was invalid.
Right.
And all the grounds for why it was invalid. But the judge addressed all the reasons why it was a valid instrument and was sufficient to convey the mortgage from MERS to Deutsche Bank.
Okay.
I also know,
And you're saying that can be done simply on the record, that there was no need for an evidentiary hearing of any kind?
I think yes, I think it's analogous to what was the concern in the Bailey and Hendricks cases in the context of a summary process action. And in those cases, it's sufficient to show title that you have a certified copy of the foreclosure deed, certified copies of the assignments, and that's sufficient to show superior title in that context. I suggest that same standard, if it's good enough for a summary process, it should be good enough for the land court as well. And there's the
So if somebody wants to go behind the documents and say that they were not invalidly executed, there's no way of doing that?
Yes, there is, but you'd have to, and this goes to the issue of whether an assignment is either void or voidable. And if it's so that's the first step that's made, and the assignment was determined by the judge to be voidable and therefore valid. And doesn't allow to go beyond the instrument itself, the assignment itself. The other issue is the time that the action to try title is filed. It's filed, in this case, after the foreclosure has already taken place. And this is similar to the situation in Schumacher, which this court decided in March after the briefing in this case. But in that case, the court remarked that it's better practice for the mortgagor to file a equity action, a TRO, or file a TRO or preliminary injunction before the foreclosure sale occurs. And in fact, the mortgagor receives all its notices, notice under paragraph 22, the 35A breach letter that says you have the right to go to court to challenge this.
So, but Varian, Judge Piper's decision, would say you can bring a tri-title at that point, correct?
Yes.
Which is different. I mean, I understand it's different than this case, but you don't agree with that, is that right?
No, well, the lower courts are all over the place on that issue. Some say, and I believe it's the Jepson, Lemelson federal cases that say you don't have a right to bring a tri-title action before the foreclosure because...
What's your position?
Well, I agree with that position.
That's Judge Foster's position.
That's Judge Foster's position.
So, but on that point, if one of the things that you need to show is that you have record title, and and the foreclosure has happened, and the foreclosure deed has been recorded. How do you show that you've got record title anymore?
Well, because they're on record. The assignment and the foreclosure deed are on record that support that the foreclosure was valid.
No, I'm sorry, if you're the petitioner, if you're standing in Mr. Abate's shoes, and I mean, this is just my lack of knowledge of, but if one of the things you need to show is that you've got record title, right,
Yes.
as a petitioner, right?
Yes.
So, is it okay that you had it? I mean, in other words, he currently doesn't.
Well, I think that's the value of having a motion to dismiss. It tests the record title of the petitioner. In this case, all he had was a deed going back prior to the mortgage that was foreclosed on. That's his only title. Well, it gives the opportunity for the respondent to say, well, we conducted a valid foreclosure, we've recorded the documents, and therefore we hold superior title.
Yeah, but there's no way of knowing whether or not the mortgagee, in fact, had record title. Is there? Just because they conducted the foreclosure, they may not have been the mortgage holder of record.
Yes. Well, if the hypothetical situation is the mortgage is recorded. He gets a deed to the property, records a mortgage, so we know what the name of the mortgagee is. Well, when the mortgagee assigns the mortgage, that assignment is on record. And that's the party, if you go to the foreclosure deed has the name of the mortgagee on it that's bringing the foreclosure. So there's a chain that's on record, it's a public record, easily obtained. You can go sit at home and look at your computer and see it. It's an easy thing to do. And plus, they've received notices. There's a 35A notices. There's the 22 notice under paragraph 22 of the mortgage. There's when servicing is transferred, they receive a notice of who the mortgagee is.
What action can they bring at that point, pre-foreclosure? You're saying they can't bring a
They could
tri-title?
bring an equitable action.
You're saying if they're limited to bringing an equitable action, they can't do a tri-title action?
That's right.
And that's because until there's a foreclosure, there is no competing title, right?
That's correct.
I mean,
They're complementary.
The mortgage is not a title for those purposes.
That's right.
And that's what Judge Foster was saying.
That's correct.
So what's the difference between saying you should file a counterclaim and then move for a judgment on the pleadings as opposed to doing what you did?
Well, I think then that gets into the issue which you raised with the petitioner of the burden of proof. And I think it unfairly shifts the burden of proof to the mortgagee to show the title, whereas in a declaratory judgment action or equitable action, the burden of proof is on the mortgagor.
But how hard is that to do? I mean, if what you said in response to my question by way of illustration, all you have to do is produce the documents that establish a chain of title.
Well, it is extra. It's an extra burden on the mortgagee to do that, where if
Well, it costs, beyond the cost of obtaining certified copies from the Registry of Deeds, you get the copy of the deed into the mortgagor, the mortgagor's mortgage, the assignment of the mortgage, and then the foreclosure affidavit. Isn't that your prima facie case?
yes, that's true. I think you have to look at the overall picture, though, which is you have people that depend on the recording system to show record title. Now we've gone through this whole process, and we've recorded properly. We've recorded the assignments. We recorded the foreclosure deed. Now we have a person that wants to buy the property, a third party, to say. They have to worry that a petitioner is going to come in at this late date and start raising these issues. There has to be a counterclaims, and it chills the market. People should be able to depend on the. I think it casts doubt on the recording system.
And you're saying it wouldn't, I mean, since theoretically the petitioner could still do that, right? You're just saying as a practical matter, he wouldn't, because he would have the burden of invalidating it? Is that what you're saying?
Yes. That's one of the arguments, yes. I'm over my time for my brother to argue. Thank you.
Good morning. Bobby Brochin on behalf of Mortgage Electronic Registration Systems, Inc., or MERS. Just quickly, by background, MERS's interest in the property was by virtue of Mr. Abate agreeing to designate MERS as the mortgagee back in June of 2005. Then 5 years later, in December of 2010, MERS assigned the mortgage that Mr. Abate gave MERS to Deutsche Bank.
And was that recorded in the registry?
And that was duly recorded in the public land records. So effectively on December of 2010, MERS had assigned away all of its titles and interest in the mortgage that were granted to it by Mr. Abate as a matter of contract law in the mortgage. So as of December 2010, when it was duly recorded in the public land records, MERS no longer held or claims to hold any title or interest in this property. And that is exactly what Judge Foster held in his April 3rd, 2013 order dismissing MERS. He said, quote,
But let's just assume this were, that somebody said, I mean, that this were actually before Judge Piper, who takes a different position, that is, that when the petition is filed by the mortgagor and has record title and alleges that the mortgage assignment was invalid, and so he might say, okay, we get to the second stage, and now it's going to be up to the mortgagee to show that actually it does have title. Wouldn't you in that instance, or would you in that instance, because it's this year and you've actually assigned it to Deutsche Bank, as you said, would you come in and disclaim, or what would you do in that situation?
well, I think you hit on that issue when you asked the question about the validity of the assignment, because that's really what triggers the disclaimer of MERS's interest. In other words, if that assignment is valid in December of 2010, which it was, then MERS would say
wouldn't doubt that.
it disclaims interest. If it's not valid, then what would happen, the status quo would be, not only would the assignment not be valid, MERS would be the title holder because it would be the mortgagee, because it would not have made a valid assignment. But Judge Foster dealt with that. He dealt with that, and I would refer this court specifically to his December 10, 2012 order, which dismissed Carrington and Deutsche Bank.
But he does talk about MERS as effectively disclaiming. And so my
Exactly.
question is really, if you were doing it the other way, would you have in fact disclaimed?
I believe MERS probably would have, and the reason it would have is because the assignment was valid as a matter of law. And there's no evidentiary hearing. That's why Judge Foster was correct to deal with it as a matter of law. This is not a factual issue. And again, his order of December 2012, in detailed analysis on pages 14 through 22, goes through the legal analysis as to why that assignment in December of 2010 was valid. And since the assignment he held, I believe correctly, that because the assignment was valid in 2010, you, MERS, thereby, at that point, divested and disclaimed any interest and title that you had in the property, and therefore should be dismissed.
So are
and
you
was.
saying that the two, well, for lack of a better word, the two judges' different procedures, really have no practical difference?
That's exactly what I'm saying. And I don't believe.
It's all a matter of law as to whether or not the assignment is valid, and it's not a question of who has the burden of showing that it is or is not.
Exactly, because in this case, this issue that clouds the title, the issue that clouds the title is purely a legal issue as to whether that December 2010 assignment was valid. If as a matter of law it is, which it was, as Judge Foster correctly held, then there's no need to have an evidentiary matter. Burden of proof really becomes irrelevant. It's a
But
motion
do
to
Judges
dismiss.
Foster and Piper have differing views as to whether or not the mortgagor can look beyond the transfer, the assignment itself, to determine whether the assignment was valid or was void or voidable.
Yes, I'm not sure they have differing views. I think the issue there is for it to be invalid in terms of title, it has to be void. Because if it's voidable, then that still means the assignment is valid. I mean, the law is if a transfer, an assignment of mortgage is voidable, the law is clear, and again, this is what Judge Foster articulated, and he distinguished between voidable and void. Some claims were that it was void, some claims it was voidable. But in those instances where it is voidable, the transfer itself, the assignment here, the December of 2010, let's say it is voidable, and the grounds are based on voidable, that assignment is still valid and binding as a matter of law.
And the mortgagor does not essentially doesn't have the rights of the assignor or the assignee to determine whether or not, or to inquire whether or not it should be deemed void.
That's right, because that's the mortgagor is not involved in that assignment, and it's not void ab initio, so it affects the mortgagor. It's just voidable, which would mean an act really between the person who actually signed the assignment and its principal, MERS, as to whether that act should go through. And only MERS in that instance would be the party to say, you know, that act that was voidable, we ratify that act. And you can ratify it by not doing anything. You can ratify it by, as they did here, disclaiming the interest in the property anyway. And that issue has been thoroughly discussed in the federal courts by the First Circuit, in Culhane decision, Woods decision, Mills decisions, and they all essentially looked at Massachusetts law and concluded that if it's voidable, that assignment of mortgage is still a valid and binding transaction. If it's void, ab initio, which is purely a legal issue, then the mortgagor would have a right to challenge it in the sense of a foreclosure context, since that transfer of the mortgage is necessary, or assignment of the mortgage is necessary under Abanez to go forward with the foreclosure.
All right, thank you.
Thank you.